Okay, a good day to all of you and welcome to our second Altius webinar, Life Sciences webinar on a very particular subject, vaccine liability. What if vaccination goes wrong? This webinar will be presented by myself, Christophe Ronse, who is a partner in the IP and Life Sciences practice group of Altius, and I will be very happily for me, assisted by Lauranne Truyens, who is an associate within our dispute resolution practice group. Why this subject? We see like you in the press that vaccine liability is perhaps not a practical issue, but at least questions are raised. We see on the one hand question marks being raised in respect of liability limitations inserted in the supply contracts concluded by the Commission with a number of vaccine suppliers. On the other hand, there is, the clear fact that these vaccines have been developed in a very short period of time, that longer-term effects of adverse events possibly might not have been fully investigated, that this represents a risk for the vaccine suppliers, not to talk about the fact that some of them have started production even before their vaccine was authorized. And I think more generally, the subject matter is of interest because somehow, and this is more of a philosophical issue, we have all become patients, which is the reason why I put in this slide. Nevertheless, today will not be about philosophy, but about liability under Belgian law. And we are going to talk about, first of all, Lauranne is going to talk about the general liability regimes under Belgian law. She will then focus on the Product Liability Act of 91. And after that, I will take over to develop a number of considerations in respect of the present situation. And if time allows, discuss some other issues. But this being said, I think not philosophy will save us, but evidence-based medicine. And I will save you for the time being from myself by giving the floor to Lauranne.
Good day, everyone. As explained by Christophe, I will start with explaining the most relevant liability regimes for products under Belgian law. Hidden defects. The rules on hidden defects are included in Article 1641 and further of the Belgian Civil Code. And to rely on these rules, the defect must be sufficiently serious, which means that the defect makes the product unfit for the intended use, or it reduces the use of a product in such a way that if the buyer would have known about the defect, he would not have bought the product, or he would have bought the product at a lower price. The defect must also be hidden, which means that when the buyer bought the product from the seller, the defect was not visible, invisible, or not observable. And if these two conditions have been complied with, then the buyer can address a claim to the seller. And if the seller was not aware of the hidden defects, then the buyer can return the good and request a refund, or he can retain the good and request a partial refund. However, if the seller was aware of the defect, or if he should have been aware of the defect, then the buyer can request a refund and all damages resulting from the defective good. Professional sellers have a duty to investigate a product before they sell the product, which means that they are liable for the damages caused by a defective product because they have this duty to investigate products before they sell them, only if they can prove that they could not have been aware of the defect because of an irredeemable error, they will not be liable for the damages caused by the defective product. Next, Belgian law also knows the principles laid down in Article 1382 of the Civil Code. If you are a victim and if you can prove that someone has committed a fault, and if there are damages, so if you have suffered damages as a result of the fault that has committed by a third party, and if you can prove that there is a causal link between the fault and the damages, then you can address a claim based on Article 1382 of the Belgian Civil Code. This brings me to the rules regarding product safety. And these rules are incorporated in the Belgian Code of Economic Law. It should be noted that there is no liability regime included in the rules regarding product safety. So if one of these rules is breached, for instance, because an unsafe product is sold, then you can address a claim based on Article 1382 of the Civil Code. If the unsafe product also breaches the Product Liability Act, then you could also base your claim on the Product Liability Act. However, it should be noted that a dangerous product is not necessarily a defective product within the meaning of the Product Liability Act. And last but not least, the rules on product safety are subsidiary to specific legal regimes, such as legal regimes for medicaments. I will also discuss the Product Liability Act, but before I'm going to do that, I want to tell you something about medical practitioners' liability. Two types of situations should be distinguished. You have extra-contractual situations and contractual situations. In extra-contractual situations, one can rely on Article 1384 of the Belgian Civil Code. And this article provides that for instance, a medical practitioner, such as a doctor, is liable for the goods in its custody. So if a medical practitioner, such as a doctor, uses a defective good, and if the use of this defective good results in damages, and if it can be proven that there is a causal link between the damages and the defective good, then the custodian, for instance, the doctor, will be liable for the damages caused by the defective good. In a contractual situation, so in a situation where, for instance, a patient has concluded a contract with a doctor, doctors and other medical practitioners have a safety obligation. And this safety obligation implies that they have to use appropriate materials. The safety obligation is derived from Article 1135 of the Belgian Civil Code. And in short, if you want to rely on the safety obligation, you again have to prove that a defective good, for instance, a defective material was used by a medical practitioner, that the use of this defective good has caused damages, and that there is a causal link between the defective good and the damages. This brings me to the next part, the Product Liability Act. And the Product Liability Act transposes into Belgian law the Directive on Liability for Defective Products. To fall within the scope of the Product Liability Act, there must be a product. And a product is defined as a tangible, movable property. So the question is a vaccine a product within the meaning of the Product Liability Act? And the answer is obviously yes. To fall within the scope of the Product Liability Act, the product must be defective. And this means that the product does not provide the safety that one can expect, taking into account all relevant circumstances. And the Product Liability Act refers to three categories of circumstances, although other circumstances can be taken into account. So the first circumstance referred to in the Product Liability Act is the presentation of the product. And this can refer to the packaging, the label, the information that is mentioned on, for instance, a vaccine, a medicine, or the information that is not mentioned on the product. The next circumstance referred to is a normal, reasonable, and foreseeable use. So that is the use that is made of the product. And the third circumstance referred to is the time of circulation. So the safety of the product will be assessed at the time of circulation. And then there must, of of course, also be damages, and these damages can be twofold. There are damages that can result from death and personal injury, including moral damages. These damages can be claimed based on the Product Liability Act, and examples of this category of damages are, for instance, funeral fees, doctor's fees, hospitalization or medical treatment costs, etc. You can also request to be compensated for damages to goods normally intended for private use or consumption, so not for professional goods. Next, so if there was a defective product, and if the defective product has resulted in damages, there also must be a causal link between the defective product and the damages. And in Belgian law, this is evaluated based on the theory of equivalence. So you will have to prove that without the defective product, the damages would not have occurred the way they have occurred in your specific situation. In case of medicines, the case law has made a distinction between general and individual causality. The burden of proof, well, the burden of proof lies with the victim. So the victim will have to prove that a defective product has caused damages and that there is a causal link between the damages and the defective product. The next question is, well, what is the standard of proof? Because this is not defined in the Product Liability Directive. So the standard of proof is determined by national law. And in Belgium, it is stated that a serious, precise, and concordant presumption, with other causes being excluded, is sufficient to rely on the Product Liability Act. So no scientific certainty is required. And this is also in compliance with the case law by the European Court of Justice. And if all the aforementioned requirements have been complied with, then the producer of the product will be liable for the damages. And the producer of the product is defined in the Product Liability Act as the manufacturer of a part or component of a finished product, the producer, manufacturer of a raw material, an importer into the European Union, or every person that presents himself as producer or manufacturer, for instance, by including his name or brand on a packaging or on a product. And this also includes the holder of marketing authorizations. It should be noted that the producer cannot exclude or limit his liability towards the victim. He can only do so in the supply chain, but not towards the victim. There are, of course, certain exemptions, certain defenses that can be relied upon, by the producer. So if the producer can prove that some of these or one of these situations is applicable, then he will not be liable. And the exemptions that are indicated in red will be discussed further on in this presentation by Christophe. The timing, it is important to note that the statute of limitation is 3 years. So this time period starts to run at the moment when the victim reasonably could have been aware of the damages, the defect, the causal link, and the producer's identity. So within this period of 3 years, he needs to file the claim based on the Product Liability Act. A claim based on the Product Liability Act can also expire after 10 years. And this expiry period, so this period of 10 years, starts to run when a product is put into circulation. And the notion putting into circulation is mentioned in the Directive on Product Liability, but it is not defined in this directive. And the Belgian legislator has defined putting into circulation in the Product Liability Act in Article 6. And regarding vaccines, it should be noted that a vaccine can be considered as put into circulation once the vaccine is delivered by the manufacturer. And then I will now give the word back to Christophe.
Thank you, Lauranne. As you will have understood from this general introduction, the matter is relatively complex and in any instance very casuistic. And at the Belgian level, whenever we see issues of product liability, it is not seldom that the Product Liability Act will be invoked in combination with other legal grounds, such as in particular, of course, tort liability, or depending, of course, upon the situation, possibly contractual liability. I would like, first of all, for the main part of this presentation, develop a number of thoughts in respect of relevant issues which could arise whenever vaccines which are put on the market in respect of COVID-19, and there are already 2 of them authorized by the Commission. The third one is forthcoming, as I understand. Whenever these vaccines would lead to adverse events, and I would like to discuss in particular the relevant issues which would allow or not allow to consider such vaccines as defective in view of the Product Liability Act. But first we have to set the scene, because as you heard from Lauranne, the decision whether or not a product is defective will be reviewed by the courts, taking into account all circumstances. And a first circumstance is, of course, that at least the 2 vaccines which are presently on the market, and the third one will follow, as I mentioned, that these vaccines are not subject to a final marketing authorization, but to a conditional marketing authorization in the sense of Article 14.7 of Regulation 726 of 2004. Meaning that we are in a situation where all the relevant clinical data are not available. And it is possible, under certain circumstances, for an applicant to obtain such conditional market authorization. The conditions have been set out in the Commission Regulation 507 of 2006. As I mentioned, it's conditional. It's only valid for 1 year, although renewable. It is, and obviously in respect of COVID vaccines, that is even more the case, subject to specific measures of enhanced pharmacovigilance, reporting obligations which are strengthened, follow-up by the authorities, which is specifically regulated and organized at the level of the European Medicines Agency. And I would certainly invite you to take a look at their website in that respect. And generally, of course, also subject to the continuation of ongoing clinical trials. And that is the case for the presently authorized vaccines. Now, as you will understand, this type of conditional marketing authorization is exceptional. It's only allowable for certain types of medicines, treating life-threatening diseases, or, as in the present case, also in response to public health threats duly recognized by the World Health Organization of the European Community. In the Commission regulation, 4 conditions are set, and I think they are important also when we look at the matter from the perspective of product liability. Of course, clinical data must be upcoming. The product must be used in order to treat unmet medical needs. So there must be no satisfactory therapy available, or at least the product, the vaccine, must represent a major advantage. And important, there must be a positive risk-benefit balance. So the risks and benefits in terms of quality, but of course, mainly also efficacy and safety, must be balanced, and the outcome must be positive from the point of view of patient health, but also public health. And that is the fourth point, is that the lack of data, in particular on possible side effects, for example, should not outweigh the benefits to public health. So there is a kind of comprehensive review which must be done, which has been done in the present situation on a very expedited basis, with rolling reviews, as they say, whereby the time for review has been shortened very substantially. It's not only the marketing authorization which would, of course, come into play here. We are talking about a vaccine which is being purchased based on commission agreements with vaccine suppliers on behalf of the Belgian state, which through the Medicines Agency is also, as I understand, involved in the supply of the vaccines at the Belgian level. And there is, of course, the whole infrastructure and all the people involved in the administration of the vaccine, from the pharmacy, hospital pharmacy, to the physician or nurse who will administer the vaccine. And last but not least, of course, one of the players is the producer of the vaccine within the meaning of the Product Liability Act, so the manufacturer of the vaccine, and or the holder of the marketing authorization. So we can imagine various situations involving various liabilities at various levels. And obviously, we can only hope that no mistakes or faults will happen somewhere. Just as a reminder, it is accepted in theory at the national level, but this should, of course, also be possible at the European level, that the authority granting a marketing authorization can commit a fault. And of course, it does not suffice that a marketing authorization would be granted to a product which would appear to be defective subsequently. No, there can be I would say, tort liability at that level through manifest faults in the review, or through faulty follow-up once the marketing authorization has been granted, if, for example, very serious adverse events would be ignored. Is this of great interest? Well, if you want to proceed before the Court of Justice, because that is the competent court, probably yes, but this is only an aside. Let's turn to the, of course, main issue. Let's come to the point. Under Belgian law and under European law, when could we consider a vaccine to be defective and thus to give rise to liability on the basis of the Product Liability Act of 91? Starting point is, of course, as Lauranne mentioned, that products which are dangerous are not necessarily defective, and this is even more true for medicinal products, which are, in view of their composition, the profiles of side effects, and so on, unavoidably dangerous to cite a legal doctrine. Anyhow, there can be defects. Traditionally, 3 types of defects are being identified in terms of medicines. Of course, obviously, but this is of lesser relevance, perhaps, for our presentation, defects resulting from faulty manufacture. More interestingly, defects in the design of the product and defects in the information of the patient. And we come back to the criterion set out in the Belgian Act and also in Article 6 of Directive 85/374 on product liability. When will there be a lack of safety? When will a product be defective? Well, if it does not provide the safety which the public is entitled to expect, taking all circumstances in account on a non-exclusive basis, including the 3 points mentioned by Lauranne. So the presentation of the product, in particular the patient leaflet, the reasonably expected use, but this also includes what is sometimes called reasonable misuse. So the manufacturer, the producer must take into account that the product could be used for other purposes, and we are thinking in particular, of course, of off-label use, and I come back to that in a moment. And crucial in the present situation, the time when the product was put into circulation, coming back to what I just said on the conditional marketing authorization and the conditions which have led to these marketing authorizations being granted on an expedited basis under the present circumstances, this is something which will come into play whenever the issue of defectiveness would come up. The assessment in accordance with case law and doctrine is an objective one, so it's not from the viewpoint of the individual patient who is confronted to the adverse event. It is an abstracto assessment based on the reasonable, on the legitimate expectations of the public as a whole, which would make that only abnormal, unreasonable safety risks could make a vaccine defective. How is this defect determined? Which are the legal criteria? What does the case law and the legal doctrine provide in this respect? Well, traditionally, doctrine refers to two possible tests. The risk-benefit assessment, and it is, of course, similar to what I mentioned in respect of the assessment made by the European Medicines Agency or the national authority, as the case may be. Although, again, this will be an assessment from the viewpoint of the patient, of the public. So I would think that public health considerations would not be as important. But the test would, of course, then be the weighing of the gravity and the frequency of potential adverse effects versus the risk of non-vaccination. And this might, certainly in respect of COVID-19, probably different depending upon the patient group. Will such assessment in itself be sufficient? Probably not. It's not the test, as you have seen, which is provided for by the legislator, but it is something which can be done, and which also has been done in case law, to the extent that we have cases where excessive adverse effects have been considered sufficient to make a product defective. This balancing test is, I think, to be combined with what is traditionally named the consumer expectation test, and that is basically also what is provided for by the legislator. You have to look at the safety expectations of the general public, the reasonable public, of course, taking into account, and I'll come to that in a moment, of course, the available information. What can one find in respect of adverse reactions in the patient's leaflet in particular? What would be the expectation? I would think that in respect of COVID-19, also the information distributed very intensively by public authorities would come into play. and I'm not, as a lawyer, I would say, very optimistic when I see very distinguished scientists come on the TV and just assess that vaccines are safe and efficacious. I'm much more at ease when I read the information on the relevant websites, which are indeed much more nuanced, as should be the case. And again, within that context, the time of putting into circulation will be highly relevant in view of what I just mentioned. Yeah. Talking about the patient leaflet, as most of you will know, there are mandatory provisions. There is an obligation under European law to describe the adverse reactions which may occur under normal use. In doctrine, there is a discussion, should that include all effects? I think the answer is yes. If you look at the regulatory side, in particular the guidelines on summaries for product characteristics, it being said, to use the wording of the Commission, that only those effects, those reactions which have a suspected causal relationship, of course, with the product will be taken into account. Quite important, I think, also in respect of product liability considerations is the fact that Belgium insisted on using labels and patient information leaflets for the corona vaccines in the national languages, as a result of which you can find the patient leaflets on the website of the Belgian agency. What is the relevance of this information? As well, you will understand it comes into play when looking at the whole picture. It is clear that the description of the adverse event as such in the leaflet will not exonerate the producer, but it will be, of course, an important element. And again, the viewpoint here should be whether this information is correct, complete, and adequate, in this respect, taking into account the viewpoint of a reasonable patient. If we can move to the next slide. Within that context, and again, this is a besides of what we're talking about, but it might become relevant, of course, for vaccines and corona vaccines in particular, because I can imagine that there will be quite some situations where there will just be no communication of the patient leaflet to the patient being inoculated. It is necessary to take into account, of course, the role of the physician or his replacement when it concerns a nurse. Physicians are obliged to inform their patients and get their informed consent, also in respect of relevant contraindications, adverse effects, and risks. So certainly if the patient is in some risk group, obviously the obligation or the requirement for the medical practitioner to inform the patient might come into play. And of course, this will depend, this is very casuistic, this will depend upon the circumstances, the gravity of the risk, the frequency of the risk, the personal situation of the patient, to what extent he needs the vaccine, and so on. This is just the application of the general obligation of care of a medical practitioner, which is to be reviewed in order to find whether it is faulty or not, by reference to what a normally prudent, normally diligent physician would do in the same case. So this is also an element which come into play, and I imagine in extreme situations might involve the liability of the medical practitioner who would perhaps have failed to inform a particular patient about the possible dangers linked to a vaccine. We move to the next slide. As Lauranne indicated, and that will be, I think, quite relevant in our case again, there are a number of grounds for exoneration of the producer under the Product Liability Act. I think the main one which could come into play here is the development risk exception. If the producer can show that it was impossible to discover the existence of the defect, not the cause of the defect on the basis of the state of the scientific and technical knowledge at the time when he put the product into circulation, he can be exonerated. This is an exception to the general rule, which in accordance with the case law of the Court of Justice must be interpreted restrictively, and we have the decision of the Court of Justice which indicated that was, I think, in relation to a procedure between the Commission and the UK about the implementation of the directive, where the court clearly indicated that this must be not the subjective state of knowledge of the producer, but the objective state of knowledge which he is supposed to know, including the most advanced level of knowledge, provided it is accessible. And I suppose one must be reasonable in that respect. Some adverse effect described in some very foreign language, not readily available, would probably not come into play. But it is a very strict threshold, as you will see. The burden of proof resting on the producer. And here too, of course, this exception might come into play in particular if the vaccines in question would appear to have long-term adverse effects. We come to the next slide, which is the second possible exception, which is, I think, unlikely to apply here because, again, it is interpreted restrictively. It is when the defect is due to compliance with mandatory regulations of public authorities. And it has already been decided that the difficulties linked to the adaptation of a notice of a patient leaflet are not sufficient in this respect, assuming that an authority would never refuse to adapt the leaflet in order to insert information on relevant adverse effects. But perhaps in extreme situations, one could imagine that this exception might be played out if the producer, the vaccine supplier, is obliged to do things which he opposes. We go to the next slide. I told you that I would say something about off-label use because apparently this will also come into play with vaccines and COVID vaccines. We read in the press that the dosage, or at least the succession of dosages, might not be respected. There is the issue, of course, of applying the vaccine to non-authorized age groups. There is the issue which even came up in the press that the vaccine would be co-administered with other vaccines and so on and so on, issues which I would qualify as off-label use. A very interesting subject under Belgian law. It's not legally regulated. There is discussion in the doctrine whether or not off-label use could qualify as an experiment under the Act of 2004, still on experiments. I would think that's not the case, to the extent that an experiment, of course, is in first instance destined to increase medical knowledge, not to treat the patient. But it is somehow questioning that I must read in the press that we are all part of some great experiment. I think, legally speaking, in any instance, that should not be the case. We move to the next slide. Of course, off-label use is problematic in terms of liability, to the extent that it is a decision by the treating physician. Informed consent will be necessary in that respect. And of course, the question who is liable will arise, depending upon the circumstances. The principle being, at least in Belgium, if we can believe at least the viewpoint of the Order of Physicians, that the primary responsibility will rest with the medical practitioner. But of course, there are situations where the product could be viewed as defective also, and the producer's liability might be involved if he should have known about the off-label use and did not take the necessary precautions in that respect. This slide, just again as an aside, to indicate what could happen if at some point off-label use would be promoted by the authorities. There is a legal basis in respect of unauthorized medicines, where the implementing royal decree on medicinal products already provides for a waiver of liability linked to the use of the unauthorized medicine, and one could imagine that the same should apply in respect of off-label use. Moving to, because time is pressing due to the loss of time we have encountered. Apart from liability, of course, there are a number of avenues which we should explore in respect of COVID vaccines. As some of you will know, at the level of FPA, the European Federation of the Pharmaceutical Industry, Innovative Industry, there is a clear suggestion in respect of COVID vaccines to provide for some non-adversary general compensation scheme, which is probably not a bad idea if one looks at the problems which a patient could encounter in order to be compensated. This already exists to a certain extent at the Belgian level, and this could obviously come into play in the unlikely event that the use of vaccines, of COVID vaccines, would become obligatory. And here too, it's probably interesting to have a look at what the present legislation provides for in respect of the compulsory vaccination against poliomyelitis. We have heard in the press the remark, which is, I think, very well founded, that we need a corona law, which could be used as a basis for the very stringent, far-reaching measures which the government is taking in order to fight COVID. Well, as a matter of fact, this law, in a certain way, already exists. It's the health law of the 1st of September 1945, allowing the king to take all types of measures, including emptying ponds with all types of miasmas and possibly unwelcome animals and organisms, but also, so it's basically a law which is very much inspired by the Ancien Régime. It replaces a decree of 1792, as a matter of fact. But it also allows, indeed, the undertaking to take measures in order to fight transmissible diseases which are a danger for public health, and to impose mandatory vaccination, which would be in the form of a criminal sanction if you refuse. And in that context, I would like to point out the fact that if indeed such obligatory vaccination leads to damages, and if no other avenues are open to the victim, that there is a residuary competence of the Council of State to provide for compensation equity, taking into account all the circumstances, and to compensate in particular the extraordinary moral or material damage which is caused by a public authority, in the present case the Belgian state, imposing vaccination. But it must be extraordinary, so it could only be applied if these adverse events are sparse. And it has been applied a number of times in respect of the polio vaccines. Secondly, we must be aware, of course, of the fact that the compensation scheme already exists under the law of the 31st March, 2001, on the compensation of damage from healthcare. It's a law which has come into effect a couple of years ago. It sets up a fund for medical accidents, and the purpose is to compensate damages resulting from the healthcare, which could include the prescription and administration of vaccines. There are special provisions in respect of an accident with or without liability. In case of liability, and if compensation is not forthcoming under certain circumstances, the fund can already compensate the patient and take over the liability claim. There is also a provision here too, when we talk about non-liability compensation schemes, a provision for accidents without liability, although it is limited in scope. The conditions are set out on the slide. It must be linked, so the accident must be linked to healthcare. That's quite easy. It must be in a situation where no liability is involved. It must not result from the state of the patient, so comorbidities will not be taken into account. And it must result in an abnormal prejudice which should not have occurred taking into account the present state of the science, the state of the patient, or his objectively predictable evolution. So it is, again, rather exceptional. So wrong diagnosis, a therapeutic failure, the death of the patient, etc., will not suffice, although totally unexpected adverse events might also qualify in that respect. And only a limited number of severe prejudices will be compensated. We move on to the section on enforcement in order, to finish this presentation. I think it's important to note that the Court of Justice has opened the door somewhat for class actions, and class actions are also existing and provided for under Belgian law when a group representative like Test Achat can take collective action in respect of a defined number of, a specifically defined group of victims in case of infringement or of particular legal provisions, such as indeed also the Product Liability Act. This could theoretically be possible in respect of vaccines to the extent that the Court of Justice in the Boston Scientific case has accepted that a potential defect could suffice in order to make a certain product And why not including a vaccine defective? If this potential effect is, of course, linked to the same group or the same production series of products. So this is something to take into account. And I will finish with the next slide, which I think is of lesser importance, is that obviously in the framework of enforcement, one must take into account possible application of international private law rules. Within the European Union context, obviously there will be the, depending upon whether it is a contractual or a non-contractual liability, the Rome regulations and the Brussels regulations. Note that Brussels 1 bis regulation in respect of jurisdiction. Note that the Court of Justice has decided that the place of the event in accordance with Article 5.3 of the regulation Brussels 1 bis of the event giving rise to the damage is the place of manufacture. But nevertheless, despite that, there is little doubt that a patient who suffers damages in Belgium would be entitled to sue in Belgium in view of compensation of the damage which he himself suffered in Belgium as a result of a possible defect in a vaccine. So this brings us to the end of our presentation. I